Lordship, I'll be in the brand level. Yeah, Lordship, I have sent the affidavit for waiting. So a week time may be granted. So as to enable me to file the affidavit.
Please, your Lordship.
Yes.
Lordship, there is an urgency in this case. The petitioners before your Lordships are the Nagaland Home Village Card Associations, about 10,000 personals. Presently, they are paid only a fixed honorarium of rupees 3,000 per month. Lordship, they have a very glorious history of even winning several Ashok Chakras. But even now, only accordingly, Lordship, on 9th of October last year, my learned friend made a submission that affidavit instruction has been received in affidavit to be filed. But it was not filed till date. On 2nd of February, last chance was given to him. So my respectful submission is that a date may be fixed. A short date may be fixed. And in the event if the respondents fails to file their affidavit, on the basis of the report, it should be decided. Because in any case, Lordship, minimum wages.
Yes.
So date may be given, Lordship. Fixed date may be given.
The learned Additional Advocate General, Mr. So-and-so, appearing for the state respondents has submitted that the affidavit, that he has already prepared the affidavit and sent it for vetting. So therefore, Mr. So-and-so has prayed for some time to file the affidavit in opposition. On the other hand, the learned senior counsel, Mr. T. Massa, appearing for the petitioner, has submitted that a fixed date may be given for filing the affidavit in opposition by the state respondents. Yeah, after
In fact, last date given already, Lordship.
Okay. After hearing both sides, the prayer of the state respondent is allowed. On 9th of March, please dismiss on 9th of March.
And failure on the filing of the affidavit should be decided on the basis of reports. Only that then they may be activated to file.
Let them file the affidavit on 9th.
Not because last chance was already given. Last chance given on 2nd of February.
No further chance shall be given to the state respondents to file the affidavit in opposition.
May it please Lordship.
Yes.
My Lord, I bet to mention admission 2. Admission. My Lord, pleadings are over. So today I have some difficulties. May I pray that this matter be adjourned for today, and this is after 3 weeks. I have requested my senior colleague also to accommodate me. I have some difficulties today.
Okay.
Let it be on 2nd or 3rd, Lordship, next week.
My Lord, if we can be after 2 weeks.
After 2 weeks.
Yes.
On 16? 16?
My Lord.
The learned counsel, Mr. So-and-so, appearing for the respondents. Prayed for an adjournment on personal grounds. Heard the learned senior counsel, Mr. C.T. Jamil, appearing for the petitioner. The prayer of the respondent is allowed. List on 16 March
For admission hearing, Lord.
for admission hearing.
Majo.
My pleasure, Lordship. Lordship, I beg to mention item number 12. Lordship, here
Item number 2.
12, Lordship.
Huh?
Item number 12. 1, 2.
Oh, 1, 2.
Lordship, here I have received my instructions, so if 3 weeks time will kindly granted to me, Lordship.
MS so-and-so appearing for the state respondent has submitted that she has already received the instructions and she is going to file the affidavit in opposition. Therefore, she prays for some time. RMS so-and-so appearing for the petitioner. The prayer of the state respondent is allowed. Least after 3 weeks.
I will pledge.
Please, Your Lordship.
Yes.
I may be allowed to mention item 14, Your Lordship.
Hmm.
Your Lordship may kindly grant 3 weeks time to file counter, Your Lordship. I have received instructions, so.
Okay, MS so-and-so appearing for the state respondent is saying that she has received the instructions and needs some time to file the affidavit in opposition. Heard Mr. So-and-so appearing for the petitioner. The prayer of the respondent is allowed. Least after 3 weeks.
Much obliged.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 8.
8.
Lordship. And for the respondent number 3, Lordship, kindly give us some time to file our affidavit in opposition, Lordship.
I have no objection, my lord.
Mr. So-and-so appearing for the respondent number 4.
3, Lordship.
Respondent number 3. Prays for some time to file the affidavit in opposition. Mr.
Please,
So-and-so
Lordship.
appearing for the petitioner. Has no objection.
There is
The prayer of the respondent is allowed. Least after 3 weeks. The interim order pastile shall continue until.
deeply obliged, my lord.
Much obliged.
Mr. Lordship, I may be allowed to adjourn item number 6
Mm.
on the joint prayer from both the parties. All the pleadings are completed, Your Lordship. If the kindly refer the matter to the hearing list.
Okay.
And if the matter can become after 3 weeks.
Item number 6. Pleadings are already complete. Least after 3 weeks for hearing.
Much obliged.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 4. Yesterday only I have received the affidavit in opposition
Hmm.
filed by the state respondent, so kindly allow me 3 weeks time to file my
For a reply.
Yes.
Mr. So-and-so appearing for the petitioner submits that yesterday he has received the affidavit in opposition filed by the state respondents and therefore he needs some time to file a reply. RMS so-and-so appearing for the state respondents. The prayer of the petitioner is allowed. Least after 3 weeks.
May I please, Lordship?
Yes.
My lord, I beg to mention item number 13.
Yes.
My lord, here I'm yet to receive, kindly allow me 3 weeks time to file everything, my lord, here. I have received instruction.
Okay. The learned counsel, Mr.
E.T. Paphom.
appearing for the petitioner. For the state respondents.
Yes, ma'am.
Has submitted that he has received the instructions and will be filing the affidavit in the position. Mr. So-and-so has prayed for some time to file the affidavit in the position. I have heard Mr.
And so, Your Lordship, on
May-
behalf of W. Angudi, Your Lordship.
Appearing for the petitioner. The prayer of the state respondent is allowed, least after 3 weeks.
Much obliged.
Yes,
Bless your Lordship. Lordship, I'd like to mention item 10.
10.
Yes, on the behalf of my friend, colleague, Muslim. Allow us 2 weeks time to file the case.
Okay. The learned counsel, Mr. So-and-so, appearing for the state respondents, prayed for 3 weeks' time to file the affidavit in opposition. Mr. Santinga, the learned counsel for the petitioner, has no objection. The prayer of the state respondent is allowed, least up to 3 weeks.
Lordship, there's an interim.
The interim order pastile shall continue until then.
Much obliged.
Lordship, I beg to mention item 7. Here I am yet to file my reply.
Okay.
Due to the affidavit in opposition filed by the state. As such, I may kindly be granted 4 weeks to file my reply.
Mr. Santienga, the learned counsel for the petitioner has submitted that he needs some time to file the reply in respect of the affidavit in the position filed by the state respondents. Heard Mr. Anangami, the learned counsel for the state respondents. The prayer of Mr. Santienga is allowed. Least up to 4 weeks.
Deeply obliged, my lord. Lordship, in item 9 as well. Here I have received the affidavit in opposition filed by the respondents day before yesterday.
Okay.
I need some time to file my reply. As such, I may kindly granted 3 weeks.
Item number
9, my lord.
9. Mr. Santienga, the learned counsel for the petitioner has submitted that day before yesterday only, he has received the affidavit in opposition filed by the state respondents.
Lordship,
Therefore, he needs some time to file.
filed by the university, my lord.
Huh?
Not the state respondents.
Okay.
Respondent would 2 and 3, Lord.
Respondents 2 and 3.
Not by status, affidavit in opposition filed by the respondents, 2 and 3.
Yes, my
Lord.
lord.
2 and 3. Therefore, he needs some time to file a reply. Heard Mr. So appearing for the respondents 2 and 3. The prayer Mr. Santienga is allowed. Least after 3 weeks.
My lord, deeply obliged.
Obliged, Lordship.
May I please, my lord?
Yes.
Lordship, I beg to mention item 15. This matter, your lordship, if 3 weeks time can kindly be granted to me, lordship, file my counter affidavit.
Mr. N. Angami, the learned counsel for the state respondents, prays for 3 weeks time to file the affidavit in opposition. Heard MS so appearing for the petitioner. The prayer Mr. Angami is allowed. Least after 3 weeks.
I'm deeply obliged.
May I please, Your Lordship?
Yes.
May be pleased to mention item number 21 on behalf of AIME. Your Lordship, this matter pertains to retrospective regularization. And the same matter is pending before division bench, WA 4 of 2025. Therefore, Your Lordship, let this matter, WA 4 of 2025, Your Lordship.
4
Of 2025.
25. 4 2025.
Yes, Your Lordship. So let this matter come up after the disposal of the WA, Your Lordship.
MS so appearing for the state respondents has submitted that this matter may be listed after disposal of writ appeal number 4 of 2025.
Yes, Your Lordship.
Heard Mr. So appearing for the who is for the petitioner? That line is not required. The prayer of MS so is allowed. List this matter after disposal of writ appeal number 4 of 2025.
Much obliged, Your Lordship.
Yes.
My lord, please allow me to mention item 3. I mean, we are not 3 weeks time to file my amended course title and my affidavit in reply to the affidavit filed by the state respondent and the private respondent.
Okay. Mr. So appearing for the petitioner submits that he needs some time to file a corrected title page of the writ petition and also to file a reply in respect of the affidavit in opposition filed by the state respondents. RDMS so appearing for the state respondents. The prayer of the petitioner is allowed. Least after 3 weeks.
Yes. Yeah, thank you.
May I please, Your Lordship? Lordship, I beg to mention item number 1.
1.
Yes.
Yes.
On behalf of learned counsel Elivio Zhao, that Lordship, he is under medical treatment. Therefore, kindly grant 4 weeks time to file the affidavit, reply to affidavit in opposition.
MS so appearing on behalf of Mr. Elivil Zhao, the learned conducting counsel for the petitioner, has submitted that Mr. Zhao is presently undergoing medical treatment.
Yes.
And under ground an adjournment has been prayed for. You are appearing for the respondent.
Respondent number 1, Lordship.
Heard Mr.
Sharif Ahmed.
Sharif Ahmed, appearing for the respondent number 1. The prayer of the petitioner is allowed. When do you want it?
No day.
After 3 weeks.
After 4 weeks.
After 4 weeks. Least after 4 weeks.
Honest.
Much obliged.
That's my lord.
Yes.
Lord, big mentioning number 5.
Yes.
Lord, the hearings are completed. And but my senior Mr. P.P. Paul is out of station. But the matter can come out after 3 weeks. By admission hearing.
Okay.
I think the concern of the respondents also.
Heard Mr. Foseko Pote, appearing for the petitioner. Heard MS so and so. What is your name?
Private respondent number 15, Beniso.
Appearing for the private respondent number
Five.
5,
Four.
5 and 4. 4 and 5.
Only four.
Oh, only 4. Pleadings are already complete. So list this matter for hearing.
Yes. No, for admission hearing up to 3 weeks.
For admission hearing up to 3 weeks.
Lordship is an interim. Can let the interim.
The interim order past shall continue till the next date of listing.
Hello, madam.
May I please, Your Lordship?
Yes.
I beg to mention item number 17 and 18
Hmm.
on the hearing list. Lordship, here, earlier these two items were linked with WPC 69 of 2018, and which was disposed of. And we have filed a review petition in that writ petition. So these two may come up after disposal of the review petition. It is registered as review petition 10 of 2025.
10 of 2025.
10 of 2025.
Earlier, the WPC was 69 of 2018.
Yes.
MS so appearing for the petitioner has submitted that in respect of the judgment passed by this court in WPC number 69 of 2018, she has filed a review petition being review petition number 10 of 2025. MS so has submitted that these two matters should be listed after disposal of the review petition number 10 of 2025, as these are connected to the said review petition. Heard Mr. So appearing for the state respondents.
Lordship, I've taken consent of respondent 9 also.
Okay, prayer the petitioner is allowed. List this matter after disposal of review petition number 10 of 2025.
Obliged, Lordship.
Okay.
From the supplementary cost list for motion, item number 22.
Here in this matter,
Lordship,
notice will go.
my Lordship, this miscellaneous case has been filed for restoration of the order dated.
To recall the order.
Yes, my lord, which was dismissed for non-prosecution, my lord.
So
Here, my lord, the applicants have filed IA number 222 of 2025, praying before this honorable court for recalling the order dated 29/11/2022, passed in WBC 221 of 2019, which the petitioner had obtained by playing fraud. Now, my lord, the notice was issued on 25/11/2025. In this case, my lord, the state have engaged us as special counsels. So notice was issued on 25/11/2025, returnable within 4 weeks. Thereafter, for the second time, it was listed on 19/1/2026. And then necessary orders was directed for filing affidavit regarding notice of service. My lord, here, though we were engaged as special counsel for the case, our names were not reflected in the cost list. And due to oversight, we could not appear on 12/2/2026 when the matter was called for. My lord.
Oh,
so we were enclosed in cost list also. So in all the 4 consecutive days, our names were not reflected. So due to oversight, we could not appear when the matter was called for. And that it was not intentional, but due to oversight, my lord. So though there is lapses on our part, my lord, I beg before this court that the order that the 12/2/2026 may be recalled, my lord.
Okay, still then I have to issue notice now.
Yes, my lord. Because
Hard Mr. So appearing for the petitioners, applicants, issue notice respondents.
1 and 2, applicant parties 1 and 2.
1 and 2. Respondents 1 and 2. The petitioner shall take steps for service of notice upon the respondents by speed post. Least after 4 weeks.
Well, if I may be allowed to take by justice service because the address may not be proper.
The petitioners are at liberty to take steps for service of notice upon respondents by Dusty also.
For motion, item number 23.
Please, Your Lordship.
Yes.
Your Lordship, this IA has been preferred for seeking a extension of time, Your Lordship. As per the order dated 24/11/2025, this honorable court has.
Do you have objection?
No objection.
No objection. Hard MS so-and-so appearing for the applicants. Hard MS so-and-so appearing for the opposite parties. This application has been filed, praying for extension of time by additional 4 weeks
Yes.
for compliance with the order dated 24/11/2025, passed by this court in WPC number 68 of 2025. Para. MS so-and-so appearing for the petitioner has submitted, appearing for the respondent, opposite parties, has submitted that she has no objection if the time is extended as prayed for by the applicants. Para. Therefore, the therefore the prayer of the applicants is allowed. The time limit fixed by this court by the order dated 24/11/2025 in WPC number 68 of 2025 shall be extended to another 4 weeks. With the aforesaid direction, the interlocutory application stands disposal.
Much obliged.
For admission, item number 16.
Wait, Your Lordship.
Yes.
Your Lordship, the disputation was preferred against the electricity bills that was raised against the petitioner here. There initially, there was stay being granted. Then during the pendency of the deputation, parties have now discussed and settled the electricity dues that is payable by the petitioner. And accordingly, they have executed a settlement agreement also, which I have got by way of an additional affidavit which I filed yesterday. I think that is not on record, Your Lordship. May I ask someone to call for the record of the additional affidavit? There, we have filed the settlement agreement that was executed between the respondent number 4 and the petitioner, describing the amount due and payable by the petitioner and how we have to pay. Accordingly, the demands of the petitioner hearing is now met in view of the settlement agreement. The settlement agreement is dated 23/2/26. So I pray that the Lordship may close the matter in view of the settlement agreement.
Okay, I'll close it.
So only thing, Lordship may record the settlement agreement.
Yes, I will call for the additional affidavit. I will pass an order like that.
Yes, in terms of the petition.
Okay.
And maybe.
Okay, I'll dispose it of.
Yes, obliged.
You got it? Then you write, item number 16. Hard Mr. R. Sharma. Appearing for the petitioner. Hard the learned additional advocate general, Mr. So-and-so appearing for the state respondents. By filing an additional affidavit by the petitioner, it has been submitted that both sides have entered into a settlement agreement the settlement agreement shall form a part of the record. Pair. I have considered the submissions made by the learned counsels of both sides. Pair. Since the parties have settled their dispute on the basis of the settlement agreement, the present petition stands disposed of in terms of the settlement agreement.
Settlement agreement dated 13/2/2026.
Settlement agreement dated 13/2/2026.
Much obliged.
for hearing item number 19.
Where is the application? Find out the application. Find out the application. Which one is the application? Objections are there, but I'm not finding the application. Yes, Mr. Jamir, what is the objection here?
The petition raised petition was alleging that we should file a state over. This is the second period. More particularly, the 14th of December 2011. The NHITCL, I'm requesting respond on 23. As far as NHITCL is concerned, we have very limited role in this case. Because whatever the prayer solved by the petition motion, it has to be answered by the ministry, that is the more Ministry of Road Transport and Highways. So we are an implementing agency. Whenever the board comes up with any kind of project, they will sanction the amount and they coordinate with the state government. Of course, we are the implementing agency, we appoint the contractors. But as far as any compensation is concerned, it is only the discretion of the state government as well as the Union of India. So, and if the Union will be released the amount to the competent authority, that is our limited role.
Kindly allow me to assist here, Lordship. Kindly allow me to praise this court, Lordship. The case of the petitioner is that, Lordship. Now, for the construction of two land road, Lordship, Marangkong, Mom Tamlu, Lordship, these are very limited petitioners in this case, Lordship. Now they are here before this court because the state government has, without consulting them, Lordship, has decided to give their private land free of cost for the construction of two land road, Lordship. And so, Lordship, the petitioners are here. Before approaching this court, Lordship, the petitioner has sent representation to NHITCL as well, Lordship, which is implementing, which my learned friend has clearly pointed that they are implementing agency. So they have responded saying that since the state government write a letter dated 14 December 2011, which is impugned to your lordship, stated that the land is of the petitioners are to be given free of cost, lordship. Now, that is why they said that is the reason why they are unable to release the payment for land compensation. That is their stand, lordship. Now, the petition, having left with no other option, they have approached this court because Honorable Supreme Court is very clear in terms of land compensation, lordship, that the petitioners, once their lands are affected, they have to be given compensation, lordship.
But,
Even to the extent, lordship, yes.
But who will pay the compensation? State government or the union government?
Lordship,
who will pay the compensation? State government or the union?
It is the central ministry, lordship, MORT. But since the project is implemented by NHIDCL, it should be the NHIDCL who should be looking after it, lordship. So in fact,
instead of this, road construction cannot be stopped.
It cannot be stopped, lordship. That is why initially, yes.
Better we should hear the writ petition instead of this.
Lordship, yes. Lordship, that is also my prayer because now the difficulties are overcome. Earlier, when the IA was moved, lordship, the petitioner's stand was that okay, you take our land, but we have to be compensated. That was the position maintained by the petitioner's, lordship, and they even said that if our land we are not compensated, then we will not allow you to use our land, lordship. That was the stand. Now, with the intervention of this court, lordship, this court has given a direction to conduct an assessment, lordship, of the petitioner's land. Again, in compliance, lordship, although the direction was given in the year 2022, lordship, they have complied in the year 2023, lordship. And to that effect, even the affidavit was filed, lordship. Affidavit was filed which clearly indicates, lordship, that the petitioner's land are affected, lordship. They have even given the square feet, lordship, the area of how far the land has been affected. Now the question is, lordship, when the petitioner's land are affected, lordship, assessment has been done with the intervention of this court. State government has complied. They are the right authority to be conducting the assessment. They have conducted assessment along with the NHIDCL and other officials, lordship. Now the fact of the case is, lordship, when it is not disputed that the petitioner's lands are affected, lordship, well, lordship, isn't it a gross violation of their rights, lordship? Because Supreme Court has, on the issues of land compensation, it is said that when a person's land has been acquired without giving compensation, it is not only a violation of constitutional rights guaranteed under Article 308, but it is also a violative of human rights, lordship. So my praise in brief is that I have Supreme Court cases to satisfy this court as well.
Okay, we will hear the writ petition.
Lordship, yes.
Instead of this IA, we will go for hearing of the writ petition.
Lordship, yes.
It will be better.
Yes.
Today I will not hear you. On some other day. Next month I will hear the. You write in the writ petition, connected writ petition number 213 of 2021. You had heard MS so and so. What is your name?
Nitya Goza, lordship.
Nitya Goza, appearing for the petitioner. Heard Mr. Muazzamir. The learned counsel appearing for respondents 2 and 3.
I'm for state respondent. For 4, 5, and 6.
You were additional advocate general?
Yes, ma'am.
Heard
For the state respondent.
heard the learned additional advocate general, Mr. So and so, appearing for the state respondents?
4, 5, and 6.
4, 5, and 6. Who is for 7? 7. The chairman, Mon Village Council.
Lordship, so far nobody has represented. We have taken steps to Dusty also, lordship.
Okay.
But here the pro forma lordship responded.
So none appears for the respondent number 7. List this matter, writ petition for hearing in the second week of March 2025-26.
Lordship, kindly a date may be given.
You suggest
in
on
that
date?
case.
You suggest on date in the second week? Tuesday and Thursday.
Thank you, Mike.
19 March for hearing.
Lordship,
Yes.
For hearing, item number 20.
In item number 20, Muazamir is there. They do it in the 19th of March. Both sides are duly represented. List this matter on 19th of March for hearing.
Not so much.